SJC-13600, Commonwealth versus Anthony and Govan.
Okay, Attorney Brooks, whenever you're ready, take your time.
Good morning, Your Honors. Benjamin Brooks on behalf of Anthony Govan. May it please the Court. This case can be decided on either of two grounds. First, because imposing GPS upon Mr. Govan did not advance a government interest in a manner that outweighed the substantial privacy invasion that it caused. It was excessive and improperly administered in the first place. And second, in answer to the question that was left unanswered in Commonwealth versus Norman, because police accessed his historical GPS location data for purposes that were entirely unrelated to the reasons for which the GPS was imposed in the first place. That violated Mr. Govan's reasonable expectations of privacy and his rights under Article 14 in the Fourth Amendment, and at the very least required a warrant. I just wanted to point out at the start that it's shot-spotter technology that originally reports this shooting. Detectives respond. They collect automatically recorded video footage from various businesses in the area and traffic cameras. And then several days later, the detectives conduct this broad-based dragnet inquiry asking the probation department for the name of every individual who was subjected to GPS monitoring or electronic court-ordered monitoring who was in the area at the time, even though there was no indication at that time that anybody who had been involved in
it's clear there's no probable cause, and it's also clear it's a dragnet.
I'm sorry?
It's clear there's no probable cause to get a warrant.
Right.
And it's clear it's a dragnet.
Right.
All right,
And then,
so let me ask you about consent.
okay.
So if we find that there was consent to impose the GPS, and then it's also there's also consent to have their tracking data out accessible by law enforcement, do you lose if we find consent?
Well, if you find that, well, first of all, yeah, to answer the question directly, if you find consent, I think that consent was limited to what would
Why?
because in this instance, the consent would have to be limited to what would have been related to the proper scope of the search, right? So it's one thing for somebody to consent to wear GPS when they know that the purposes of wearing the GPS is to enforce a stay-away order or to enforce an exclusion zone, and that their location data in those areas would be infringed upon if there was an alleged violation.
But would a person objectively believe if they consent to have an ankle bracelet put on them that they are consenting to the government being able to track them?
I think they know that the government's being able to track them, but I think it's reasonable for them to assume that the only time that the government is going to access that information is if it relates to the purposes for which the GPS device was administered in the first place.
Because the scope of consent is really the issue for me, at least.
Right.
If your client had been connected to the GPS device by probation at 10:30 in the morning, and then they're walking by, they leave the courthouse, they're walking by a bank at 12 o'clock at noon, and they decide to rob the bank with the recently applied ankle bracelet on GPS device. Are you saying that they have a reasonable expectation of privacy that when they walk into the bank just a few hours later that they're not going to be tracked by the police?
I think they do, yes. And I think the reason is because consent has to be limited to what would otherwise be justified by a proper imposition the search.
Do you have
right?
any cases on consent and the scope of consent in GPS?
Well, I think
There's the usual consent rules, which I don't think help you, but
Right.
give me through any cases that
I think the best
that help you.
articulation is in Justice Wallahojan's dissent in Commonwealth versus Johnson, where it essentially says, look, just because somebody is placed on GPS monitoring, or just because somebody consents to that GPS monitoring, that doesn't mean that they're consenting that this whole universe of information that GPS data is going to collect. It means that they're consenting only to the police review or probation's review, honestly, of just those areas where it's specifically needed to enforce the conditions that would justify it in the first place.
I think perhaps comment, sorry.
Any other cases other than that dissent?
Well, then I think there are the cases that we put in the opening brief that talk about consent has to be unambiguous, both in terms of its actual giving consent, and then it has to be unambiguous with respect to the scope. And here all you have is this statement, GPS monitoring on release.
Did you look outside of Massachusetts? Because I have the same question Justice Gaziano did. Has anyone, I mean, it's an interesting question, but has anyone, other state, written on this issue about consent and GPS and how far it goes? Because you make a very interesting argument, and it may be correct, but it would be useful to know if some court has adopted it.
I didn't do that, and I would be happy to look and submit a letter to the court afterward if I found anything useful. But I do think that it is a very different thing for somebody to say, okay, I'm going to wear a GPS device, and I understand that the reason for this is because the government wants to enforce a stay-away order. So I will understand that in this, I think a good way to think about it is...
Is the condition of probation not to commit further crime?
It is, but I think from what we know from Norman is that when it's pretrial release that we're talking about, GPS can only be imposed for very specific purposes, and general deterrence is not one of those purposes. It has to be.
But here's the imposition is for, kind of familiar with Norman. The imposition of GPS is one thing, but then we have a consensual application of a GPS device, which, and we'll probably talk about whether it was actually truly consensual given the Hobson's choice that the defendant had, but it was counseled at least, unlike the other cases. So if it was consensual, and the record doesn't reveal whether it was a colloquy or anything about the scope of that consent, I'm just wondering if the average person, and that's really the test, is the objectively average person, they know they have an ankle bracelet on, what are they going to think as far as scope of consent? Just the same as when the police come up to you and say, yeah, you can search my car.
Right.
What does that mean?
Right.
So.
Well, then that is the case that's cited in the opening brief. When the police said, you can search my car, that didn't include looking at
The air
the trunk.
filter, right, yeah.
And I think that it is the average reasonable person, especially when they're faced with those coercive circumstances and they're agreeing to this,
And I'm not saying we're going to get to consent, but like we'll get to it, but whether or not it'll go in your favor because you have the coercive circumstances. But I'm just wondering if we get past that, whether you have a basis to say that the information that was given to the police was not out there, essentially.
I'm sorry, I didn't understand.
Whether the information given to the police, whether the defendant consented to have his tracking data
Right.
revealed to the police by going on the GPS.
Yeah, I mean, our position is that with respect to the expectation of privacy, that has to be, even with consent, right? Which, and under Norman, consent really shouldn't come into the constitutional analysis here. It should be separated because the circumstances were so coercive. But it should be at least as broad as his right against an improper search. And, a pretrial probationer maintains robust expectations of privacy, and it should, that expectation of privacy.
From whose perspective do we measure the scope of consent?
I think it's I think that what the case says is it should be determined by what's specifically stated in the exchange where the consent is given. And here, all we have is GPS
But
monitoring with no real,
measured against an average person.
measured against the average person or the average defendant in this situation. And I think for somebody who is saying, okay, I'll agree to GPS monitoring as a manner of enforcing a stay-away order, then their expectations of privacy should be diminished only to the extent that a later review of their historical GPS tracking data would be necessary in order to enforce that
Where do you
condition.
get that the consent was to have a GPS device only to enforce a stay-away?
Well, that's just under Norman. It's the only available reason that the Commonwealth had to impose the GPS
Well, and the
device in
judge
the first-
specifically said that on the record, right? She said, I need a stay away.
She said, usually I need a stay away.
Oh,
I
sorry,
don't
she
have
said
one
an
here.
exclusion
Right.
zone, she said, I need
Right,
an
usually I
exclusion
need
zone.
an exclusion zone, right. And so I think a good way to think about it is when a defendant is placed on pretrial monitoring for something, and then they say, okay, my reasonable expectations of privacy don't exist within this zone where I'm not allowed to go, right? Or they don't exist around this victim who has a stay-away order from me. But for this broad universe of other information, which includes literally everywhere he goes, you might even be able to track which side of the house he's staying, he should maintain a reasonable expectation of privacy in that information. And when the police go back and get that, no matter how small a sliver of information that is, that violates his reasonable expectations of privacy.
Can we
and
talk about
requirements.
consent some more? So this case is extremely different from Norman in terms of what we have about the circumstances surrounding the consent. So in Norman, as I recall, the Commonwealth was just arguing on the basis of his signature on a form.
Right.
But here, their Commonwealth had moved for a dangerousness hearing, and then clearly an agreement was worked out,
Right.
whereby the Commonwealth agreed to not go forward with the dangerousness hearing, and the defendant agreed to this whole host of conditions, one of which the judge spoke up and said, hold on a second, I think I need an exclusion zone to be able to do this. So can you give us your best argument for why, even though this was a counseled agreement with the prosecution, whereby the prosecution gave up going forward with the hearing on dangerousness, that this was not adequate consent?
Yeah, I mean, I think there's three reasons. And the coercive quality of that agreement, I think, still exists regardless of whether it's presented to the judge as an agreement or whether the judge is imposing it during the course of the proceedings. And, what Norman says is the coercive quality of the circumstances in which a defendant seeks to avoid incarceration by obtaining probation on certain conditions makes principles of voluntary waiver and consent generally inapplicable. I think this is an example of that. In Norman, we didn't really know what happened during the proceedings.
Would you think you would have to have a colloquy then?
I do think that at the very least you have to have a call.
Right, in order to get beyond that language in Norman and the coercive attitude, circumstances.
And also to adequately determine what the scope of the potential search is going to be, right? And what the scope of the potential consent is. Without a colloquy, you don't have any of that.
So in and of itself, I'm sorry, you should continue to answer Justice Stewart's question.
Well, and then I think that the other important case, I mean, what we learned from Norman, from Commonwealth versus LaFrance, from Commonwealth versus Moore, is that any time a defendant is faced with a situation where they're asked, on the one hand, to give up what their right against what, without their consent, would otherwise be an unlawful search, on the one hand, for a promise from from incarceration, on the other hand, that is a coercive circumstance.
And how do you fit into this analysis in your mind, the presumption that someone should be let out on personal recognizance unless there's adequate basis under our statutes not to? Do you think that if you are out with a GPS on you, are you out on personal recognizance?
You're still entitled to the presumption of innocence, and you're entitled to a presumption of personal recognizance. But there is a condition, and I mean, I'm not sure how to answer that.
Well, I mean,
question.
it was a friendly question, or intended to be. I mean, this is a very different situation from probation.
Right.
Because someone is presumed innocent, and so it seems like here, in order to not go forward with the 58A hearing, Mr. Govan agreed to a GPS.
Right.
And, I'm asking, when we think about consent, does the presumption of personal recognizance and the presumption of innocence, how does that fit into the consent analysis? And when we're trying to distinguish this from probation, I recognize that it's different from probation, but I'm asking, does the sort of greater liberty interest there, how does it exactly relate to the consent analysis?
Well, I think the fact that he's entitled to a presumption of innocence, entitled to a presumption of personal recognizance, all of that means that if he's giving up that right, he's giving up more, right? So the court should be more protective of limiting the scope of the consent that he gives in those circumstances.
I have one other question. So what do we do? It's the sort of the elephant, which is the police are taking GPS for all pretrial release. Anyone on a GPS, they're running these searches, both probationers and pretrial. How does that help you? How do we figure that into our analysis that they're going out there and doing these dragnets? I'm just trying to figure out how that plays into this and how we analyze it.
Well, I think that's another reason that the court needs to be protective of pretrial probationers' expectation of privacy and their presumption of innocence. And what I started to say at the beginning here is that this is a situation where the report, the investigation, the identification all takes place with these automatically generated electronic surveillance mechanisms. And then, it's almost a situation where they could make this identification.
See, but there's the nexus issue. So they are doing a search on a shooting, a location of a shooting. They're not doing, I know you described this as everywhere he goes is bad. They're not really doing that. They're looking at this one spot, and a public spot, by the way. It's not his bathroom. It's where they're shooting in public. So I'm just trying to understand how that plays out in all of this.
Right. Well, I mean, the only reason that they have access to that information about him is because he was compelled to wear a GPS device, right? And I think that to get back to some of the, what are the cases that are helpful here, the amicus brief cited to Commonwealth versus Bucella and Commonwealth versus Youssef. And in both of those situations, the court found that when the government sort of compels the disclosure of certain information for one purpose, it can't just go back and use that information for some second purpose without at least requiring a warrant.
I think Justice Kafka's question gets to the 1 hour reasonable expectation of privacy in one location and not a private location, if you could address that.
Right.
I know that either your brief or the amicus brief cites Estabrook and registration versus CSLI. Is that the point?
Say that last part again.
Registration data versus CSLI.
Right.
Is that
And
the
this
point?
this is the registration data equivalent, right? Which in Estabrook, the court says that 6-hour window that we've recognized doesn't apply to that type of information. And I think it's Commonwealth versus Almanor that's more specific there, because that was a case where.
Well, but it's Johnson too. Johnson's a probationer, not a pretrial. But we make the point that, you don't have, in that case, he was a burglar and he continues to burgle while he's on probation. But we make the point that you don't have this one data point where basically where the breaking and entering has to be analyzed, that has to be taken into account.
Right.
You don't have an expectation of privacy necessarily, particularly in that context. Whether you do in this context, I don't know, and that's what I'm struggling with.
Right. Well, I think you do, because Johnson was his GPS was put on him specifically because he'd already violated probation once for a B&E, right? And then they were going back and they were looking at that. So he knew, right, that he was under GPS monitoring specifically for future deterrent purposes, right? This is very different, right?
So Johnson's consent, this case not consent.
Right, Johnson is consent, and he's a post-conviction probationer who does not have the same expectations of privacy as a pretrial probationer.
And one of the reasons for the GPS in Johnson was to deter future crime.
Correct.
Which is exactly within the nexus of what the police was looking for.
Right. And in this case, you don't have that. And in fact, what Norman says is you can't impose GPS just for deterrent purposes. And the only reason that police would have access to this is because essentially the GPS device collects more information than it needs to in order to enforce the specific purposes for which it's introduced. And so I think when the police come back and look at that, you have to pare it down to what was just necessary for the enforcement of the stay-away order that justified the GPS in the first place, and everything else should be awarded with an expectation of privacy.
Okay, thank you.
Thank you.
Attorney Slyman.
Good morning, and may it please the court. ADA Mackenzie Slyman on behalf of the Commonwealth. With me at council table is ADA Tiffany Albanese, who was the prosecutor on this case. I'll start my argument with the consent question. And again, first acknowledging that we are looking at essentially two phases here, is the imposition and subsequent and incidental collection of data versus the accessing of the data itself. Here, the defendant clearly consented to being put on the GPS monitor. I would also acknowledge that voluntariness.
How could you say that he clearly consented in light of the inherently coercive circumstances in which he found himself? I think he had just spent 3 days in jail, was that right?
He was he had been in custody on the 58A hearing. The record doesn't indicate whether that was.
And the Commonwealth came forward and represented, what, we're not going to do the 58A because there is a condition of pretrial, which is the GPS, and so we've come to a settlement.
Yes, and I think that last part is very important here. It's not that the Commonwealth presented to the court. We've on our own, without speaking with the defendant, decided that we're no longer going to go forward with the 58A hearing. This was clearly represented to have been a result of negotiation and bargaining between the two parties.
And what was the bargaining power of the defendant?
The defendant, by consenting to being put on the GPS, no longer runs the risk, but not guarantee in any regard that he could have been held under pretrial detention.
So you can either continue to be held, or you wear this GPS, and you think that was voluntary?
I disagree that it was a binary question to that nature, because we still would have had to make all the requisite showings at a 58A hearing that there was clear and convincing evidence that the defendant was too dangerous to the community or to the named witnesses in this case to be released on that there were not any reasonable conditions of release that would have been adequate. We still had that's a significant showing the Commonwealth would have had to make before the judge in order to have him held prior to trial. So it's not a guarantee of being held, which is what the defendant was facing, I think, in Johnson 1 and in Norman, where at that point, separate from his consent to any bartering that had happened before the court placed that order, once the court ordered GPS as a condition of release, he had to sign that form, and if he didn't, it was guaranteed that he would be held prior to trial for failure to acknowledge and agree to follow that.
So assuming you've made a case for consent, what is the scope?
Sure. So I think the scope, at minimum, is and again, focusing first on the question of the imposition and the collection of data, because I don't think the Commonwealth here needs to be successful in an argument of consent for the accessing of the data. So turning first to the imposition and the collection, I'd say at the very minimum here, the defendant's consent to wear the monitor and have his data collected would extend through the time that he's wearing the monitor as a condition of pretrial release.
What is there in the record to indicate that he consented to the GPS for all purposes, including criminal investigatory purposes unrelated to the offense that brought him before the court?
So there aren't details to that degree in the record. It's just expressed as an agreement between the parties.
So for what purpose was the judge authorized to impose GPS as a condition of pretrial release? It doesn't, in my view, matter so much what the parties agree to. The parties, I don't believe, can agree to things that the judge cannot lawfully do. So would you agree with that general proposition? You couldn't say we have an agreement that the defendant should be executed. So, Judge, would you please do that?
Sure, yes, Your
Okay.
Honor, yes.
So, assuming that's true, for what purpose could the judge lawfully impose GPS monitoring in a pretrial context under Section 58?
Yes, so these are the three bases that are set out in Norman, that it's either going to be to ensure the defendant's return to court, to preserve the integrity of the judicial process, or in cases of domestic abuse, in order to ensure the safety of the alleged victim and any other individual or community.
Right, so
I'd
let's
say-
assume that the judge did that here, but nothing further, right? The judge could not impose GPS as just a general tool that might be convenient for law enforcement in the future, correct?
I would agree that I think Norman has made it clear that the parameters that we have
Right, so
in order to justify it.
how could, as a matter of law, the defendant's consent extend beyond the judge's authority?
I think that because it's an incidental to the main purpose, and then that this is where we transition now to the question of a reasonable expectation of privacy. So I think, and I'll back up.
Before you transition, so do you have a case to support your thought?
I would point to Johnson, Johnson 2, as we refer to in our brief, the Commonwealth's case there.
That's a probation case.
Sure. I would also point to Johnson 1, which I know Your Honor issued a dissent on, and I recognize that predates Norman, but.
So any case other than that shows that a defendant that is upheld, that is found valid, a defendant's consent to something the judge could not do as a condition of pretrial release?
No, I don't think, not to that specificity, Your Honor, but I think I would push back a little bit as to that the judge, so long as it's been imposed for an appropriate reason, which I think here at minimum the last two of the Norman bases have been met, that the further use of it beyond that does not disqualify the extent to which the data can be used or accessed here. And as I said, I acknowledge that there hasn't been, I don't think the court yet has reached this question to this
Did you
degree of specificity.
did you look beyond the state too? Because it seems like we're addressing some novel
Certainly.
questions. Have you done a 50 state or looked outside of Massachusetts on this?
I'm happy to look further. It's been a minute since we've briefed, so I can't recall the full extent of my searching. I didn't find anything within Massachusetts that goes to this degree. I will say I did, and I don't know that this was put in the Commonwealth's brief, but there was a First Circuit case, I think Commonwealth versus Hunt, or State versus Hunt, that I'm happy to provide the site for to the court, which deals with, it's coming out of Suffolk Superior, but in the federal court, United States versus Hunt, which is incredibly factually similar to where we are today, and that's a
It's
2021
like United
case.
States versus Hunt is a DMAS case, or what case is that?
It's out of the First Circuit, and it actually, if I can have just one moment.
And it involves this issue of, okay, we put this on for basically an abuse order, and then we go trolling for information with that. Because that's the issue, right? Because it seems like there's multiple parts to it. Okay, in this case, and by the way, don't you have a problem? Because we don't know where the victim lives, right? So this GPS doesn't do anything, right?
I would disagree because of the additional condition of a stay away from the victim in general. This isn't just stay away from her address.
But if we don't know where she lives, how is this useful? How does this work? Because didn't we deal with that in Norman? I defer to Justice Gaziano, but didn't we say that?
General deterrence, you couldn't do it.
Broad.
Yeah, you said this kind of blithely about a minute and a half ago, that the reasons for the initial imposition in the BMC case met the Norman requirements, and I'm struggling to see how, because you have a victim who even the judge makes note on the record that I can't do an exclusion zone. We can't do a stay away. The record indicates that the victim in the case didn't want her address known. The DA at the time of the hearing says to the judge, we haven't had any contact. So how would this be a proper imposition in the first place? What is it excluding, and who is it protecting if we don't know where the person is?
Sure, and if I can step back for 1 second, I don't believe in this case that this is different than I think Roderick, which Your Honor might be thinking of, where they hadn't had any contact with the victim at the time. Here we had spoken to her. She had stated she had not had contact with this defendant
Right.
for a period of time and had moved. But I think here, this defendant, this is where I think the consent comes back into being crucial here, is that had Roderick, I believe, was discussed at the BMC level, but this defendant consented to being put on this monitor without an exclusion zone. Had he not consented to that, then the Commonwealth and the court would have faced that question of, and I think this
Sorry, hold on, can I stop you there? Oh.
I'm sorry, but that again goes one step too far, because this is back to Justice Wolahojan's point. The defendant can consent to whatever he wants. The parties can go out and say, we'll consent to whatever we want with respect to obviating going forward with the 58A. But that still doesn't mean that short circuits the judge's independent requirement to make sure that there's a lawful basis to impose the GPS. And so if you've got the Commonwealth coming saying, we're going to obviate a 58A, and he consents to a GPS, the judge still has to say for what? And then say, there's a lawful basis for me to impose it.
yes,
So
Your Honor.
if there's no exclusion zone, we don't know where the victim is, what's the lawful basis upon which the judge can impose the GPS?
So I would say to that an exclusion zone would keep us out of a known area, obviously. Typically, it's going to be the victim's home address. But in situations, especially where you look at this case, it's an assault and battery with a family household member and intimidation charges, that stay-away order goes beyond just where this person lives. It's going to be their place of work or any other place where they might interact with each other. And so the GPS ensures that should the defendant find out where she is, find out where she works, find out she's going to be at a cookout at her family's house this weekend, that he knows that he's being monitored, and that if she reports, yep, he came to the house, he bothered us.
But that may not give the government the right to monitor him everywhere, right? That's the whole problem with GPS. The fact that he can be monitored in some places, and that the person he's supposed to stay away from may be in different places, I don't quite understand the logical link in saying, therefore, the defendant can be monitored everywhere, anywhere and everywhere.
Yes, Your Honor, but I think that breadth of monitoring is required where
It's to protect the victim.
correct.
The victim is going to be somewhere.
How does probation know there's a violation?
Sure, so I think, I acknowledge that, Your Honor, that where we have an exclusion zone, the GPS is going to ping probation and what logically follows
Right,
from there.
and to stay away from the victim, how's this going to be, how's this work?
I think it goes to, and this is the same as with why Norman, acknowledges that GPS is permissible to ensure someone returns to court. The probation department's not going to know their location until this triggering event takes place. So
Yeah, but probation's going to know whether or not they show up at court.
Right, so it would be dependent on the victim or anyone else who's subject, another witness coming forward to say, hey, the defendant has violated this condition of release and has approached me.
So is the purpose deterrence then? Is it deterrence or post facto evidence gathering?
I think they go together. I think
We're a little hampered here because, to be clear, the Commonwealth did not brief an argument that the imposition of GPS on Mr. Govan served a governmental purpose here, correct? You only briefed the consent issue?
our focus was on the consent issue, yes. But I will acknowledge that the motion judge did find both that there was valid consent here and also that the government's interest in ensuring that this defendant stay away from these two witnesses outweighed the intrusion.
Can we go back to a second ago, because you said that that he consented to GPS without limitation to enforcement of an exclusion zone. But the judge, it's a little unclear in the transcript because the judge says, oh, you've got this agreement, but counsel, I need an exclusion zone. And then the ADA says, well, I have, we don't have the victim's address. She doesn't want her address known. And then defense counsel says something like, well, we would consent to, an impoundment of the address. And then the judge says, okay. So the way that I understand that is that everyone thought that there was potentially going to be an exclusion zone created with an impounded address. Is that not?
I would disagree with that classification of how it took place. I do, that the judge asked, is there an exclusion zone we're going to set here? The Commonwealth stated that they did not receive an address from the victim. But that if in the occasion that we did, it's not suggesting that we're going to now take that affirmative step, but if we did become aware of her address, we would submit to the court and seek that it be impounded, to which the defense attorney replied, we have no objection to that. And I would point the court as well to later in the transcript in that afternoon session, once the defendant was brought to court, where the court expressly tells him to stay away from the address. Should he learn of it, he says that's fine. So I don't think that there was this expectation that the Commonwealth would be taking affirmative steps to get an exclusion zone, to get an address from the victim to then report and impound to that degree. I think this was if we do come across this information, this is how we would like to deal with it once it's here.
How does the lack of an exclusion zone, how does the lack of an exclusion zone affect the reasonable expectations of the pretrial detainee?
Sure.
Given that he knew that there was not an exclusion zone, and he also knew that he was to stay away from the victim, the only way, are his expectations that he was going to be monitored 24/7 because there's just no way of knowing where the victim was?
That's our position, Your Honor, is that by virtue of there not being an exclusion zone, which the defendant was aware of and at minimum lodged no objection to, where there is no exclusion zone, then you have to be monitored at 24/7. I'll use have to loosely there, but in order to implicate to enforce the condition in that way. So the defendant knew, and again, where the stay away, no contact is a provision that beyond a geographical limitation. It's not just you cannot contact her at her home or go to her home. It's you need to stay away from her in all ways. The defendant had to have known that he was being tracked at all times. And just turning briefly, I recognize I'm out of time, but just to the question of a reasonable expectation of privacy, I would just emphasize here, as to the first prong alone of a subjective expectation of privacy, the defendant has put nothing forward in his motion filings before the Superior Court or in support of his brief of his own expectation of privacy here.
His argument is, I get, if you're right on consent, you can put that GPS on him and monitor him everywhere. But his argument is, I have a reasonable expectation of privacy that you're not going to use it except for the domestic relations purpose. Isn't that his argument? That, okay, I understand I'm being monitored, but it's not everything in my life I'm being monitored for. I'm being monitored not to attack my spouse.
I had the defendant put that in an affidavit or express that elsewhere, I would understand that subjective intent, but here we don't have that. And secondarily, where we then turn to the question of whether that expectation of privacy would be, society would be willing to accept, I think that's also where the defendant's argument falls apart. That is addressed in both Johnson 1, which was, again, a pretrial case, and in Johnson 2, which, again, was probation, but the same question of essentially a defendant who knows that he's on GPS monitoring, just does not have a reasonable expectation of privacy in a targeted investigation to determine his presence at a crime scene. And I'll leave it with the kind of last question of whether there was an expectation of privacy that's even implicated here by the breadth of the data that was looked at. The detective first pulled a 20-minute period of time for a discrete, specific location on one date. Once he had that data, he then, of those 5 individuals, the defendant is the only one who pinged 6 times versus once for the other 4, presumably off of Columbia Road just driving past, then only requested an hour's worth of data. This was much less.
Do you have any cases in Massachusetts that say tracking data is subject to the de minimis time restriction?
So I want to make sure I answer that as accurately as possible. I would point the court to Augustine, I suppose, with CSLI. I don't know if that's the best comparison.
No, it's not. So you have historical CSLI in Augustine. Even the tower dump case deals with CSLI historical.
Right.
It's not tracking data.
Correct. So again, so I guess I would point back to Johnson 1 and 2. In 1, that was 2 months total worth of data that was accessed. And in Johnson 2, that was once the general area and the location, but as far as I was aware from the briefing, it wasn't specific to, they didn't put it in the briefs, in the decision, excuse me, how much time was requested. But this was not a situation where there was enough data to be requested to implicate that concern of a mosaic being created of this defendant's life. There's only so far you can move in an hour's worth of time.